Thank you everyone for coming. My name is Sunir Shah. I'm the president of the Cloud Software Association. Today we have a hot topic, but is I think a scary topic and quite frankly, a mind-blowing topic. And I'm not going to explain the amount of alcohol I drank while I was doing the research for this because it was so painful. But we're talking about privacy, data trade law, espionage, because why not, and SaaS partnerships, and what we're all doing in the wake of the not so surprising takedown of the Privacy Shield. It failed in court thanks to screms. I have a bunch of very luminary experts on privacy here to provide color on this topic. So I'm going to do a quick round of introductions. First, my favorite privacy policy tool and generator, iubenda. We have Abbie Clement. Would you mind introducing yourself?
Yes, hi guys, I'm Abbie Clement. I'm head of content at iubenda. So we create software solutions for compliance just to kind of make that a lot easier, marrying the legal side with the technical side because it can be quite difficult.
Thank you very much. We have William Littman from CrownPeak, head of legal affairs, and I think star of this show because he has a case study. Would you mind introducing yourself?
Sure, thanks for having me on. Nice to meet everyone. I work for CrownPeak. We are a digital experience company. We have 3 product lines. The first one's a content management platform, a CMP, where we manage the websites for Fortune 100 companies. The second one is called DQM, Digital Quality Management, where we assess the accessibility and digital governance of all sites. And the third one is a consent compliance tool, which helps companies adhere compliance with GDPR, CCPA, and whatever regulations are coming down the pike. So we're big on data management.
And we also have Micky Khanna from gdprplan.com. Introduce yourself and also maybe a little bit of your background before you end up in the GDPR world as well.
Sure. Well, thanks for inviting me to the panel. And as Sunir said, so for the last 3 years, I've been involved quite heavily in helping companies as an independent contractor on their data protection, information security, and privacy compliance obligations. Prior to that, I spent 17, 18 years in digital marketing and advertising at technology platform level, ad agency level, publisher side, particularly within affiliate stroke performance marketing for my previous 10 years prior to entering the world of data protection and information security.
Yeah, so I will say that myself, I'm extremely conflicted on this topic because on one hand, I'm a computer scientist. On the other hand, I'm a librarian, which is true. I have a degree in library science. I'm licensed to do this. And as a librarian, we have an oath to protect data privacy and customers that I actually care about quite deeply. And third, I'm a marketer. So I also don't want to do that because I want to make as much money as possible. And then now I have my own company, AppBind, which is managing these tricky issues of how do you get channel partners to buy, sell cloud subscriptions, which is not as easy as you think from a data privacy point of view. So I'm not going to lie to you that I'm not, usually I try to be a neutral moderator, but I am not, especially since I spent a god-awful amount of time building this guidebook that we put on the cloudsoftwareassociation.com blog just today, which is 5,000 words, like literally everything I could collect from our esteemed colleagues here on the situation. So I don't think we're going to be able to get into all of the details of this extremely difficult topic, but my goal here for those listening in now and in the future is to get an idea of why this is important. And from a partnership point of view, I will tell you, I've seen a lot of contracts in legal situations in the last year just through my work with AppBind that were not correctly constructed and are very concerning about what they've done. I'm like, you don't know that's not legal, right? Okay, good. So that I wanted to deal with. But like what happens as a partnership person is we are responsible for negotiating agreements from our company with other companies, which involve data transfer and other kinds of data-related issues and privacy. And ultimately, when we put a contract across the table to the other partner, we're responsible for that contract, no matter what legal says. And we need to know what we're doing. And often, you know, your legal team won't know what they're doing because they haven't thought about all these issues. So here at the Cloud Software Association, we're here to try to provide some guidance so that you can go into these situations safely, securely, and then as time goes forward, and these privacy laws continue to evolve, as they will every 6 months, there'll be a change. You are protected and doing the right thing. So that's the goal. So with that, I think I would like to stop talking for a while and turn it over to William. So CrownPeak did I learned a lot from William and what they did over there. They did a very extensive response to the Privacy Shield, and I think you have a pretty good case study. I believe you have some slides because it's quite technical to go over in detail. Kai, can you set them up with the screen share?
Sure, I'll stop my video.
Okay.
Okay, is my screen being shared?
I don't think so. Is it?
No, I don't think so. I'm not seeing it.
Well, if you can't do it, I'll share your screen for you. Just give me a second.
Okay.
Well, first tell us a little bit about why you guys were exposed to this problem.
Sure. So CrownPeak, we have three, as I stated at the top of the call, we have 3 product lines, and we have data stored all over the world. We rely on AWS. So obviously every deal, every negotiation, every partner we work with, data flow becomes a key issue in every context. So we have to stay abreast of everything that goes on. And this goes back for years. CrownPeak's been around since 2001. And the data laws let me see if I can share it. Because it would be much easier. Is it working?
Not sure. By the way, if anyone has questions, we'll wait a little break. Fire away.
Yeah, it would just be
really about you guys. Okay.
Okay, I think I'm showing again. Let me try to share my screen. Okay, is this? There we go. Okay. Okay, so big picture, on July 16th, 2020, the EU-US Privacy Shield was invalidated. If you're on LinkedIn and into the data security and privacy community, you probably panicked and freaked out. Let me just tell you, don't panic. Data will still continue to flow. As you've seen for the past month, business hasn't stopped, nor will it. I'm gonna stop the video because it's weird watching me. Okay, is my screen showing now?
I think I was sharing my screen. Is that what's happening?
Okay.
Okay, well, I'll reshare my screen. That's okay.
Yeah.
I'll do it. I could be your Vanna White. That's fine.
Okay. All right. Is it working now?
That's all right. This is why we should rehearse this instead of spending all night writing a document. Okay, here we go.
Okay. So what happened is Privacy Shield, just as a little background in history, I'll keep it very brief. Privacy Shield came in 2015, which was the last response to when everyone freaked out. What had existed for 15 years was Safe Harbor, and that came about in 2000, and that basically encompassed 7 fundamental principles that the EU considers. And you have to, at the outset of the conversation, you have to realize that the EU and US have very different views of privacy. For the EU, it's a human rights issue. You know, there's a history of World War II and genocide. So after World War II, certain rights were encompassed in the Declaration of Human Rights, and privacy is just an extension of that. So Safe Harbor was invalidated in 2014 after Edward Snowden allegations of surveillance came out, and Max Schrems, who is a EU citizen, sued for Facebook's transfer of his data from Ireland to the US. So Safe Harbor was found to be invalid. What happened after that was Privacy Shield. Privacy Shield was more of a self-policing mechanism, but there was a certification process, so it's more rigorous. And in fact, I have a team here that every year we have to go through a pretty rigorous process to get it renewed. So obviously the decision on July 16th was kind of annoying. But as I said before, the world's not ending. You know, don't panic. Data's not going to stop flowing. You know, but I think it's important to stay abreast of these issues. For now, what my company is doing, we're continuing to stay under Privacy Shield because it shows to customers, vendors, and any partner that we work with that we take privacy very seriously and that we're undergoing a rigorous process. We still adhere to Privacy Shield, but as far as the legal mechanism, we've reverted to what is called standard contractual clauses, or SCC. And that's lighter than Privacy Shield, but for now it's what's going to be valid. And my view, I won't overwhelm you with the details because I think I'm the only lawyer on this call. Big picture, I think we're going to come up with a Privacy Shield 2. The EU and US released a statement on August 10th saying they're working on it. I think we'll come up with a Privacy Shield 2. Schrems 3 will come about in 2023. They'll sue, they'll invalidate Privacy Shield 2, then we'll come up with Privacy Shield 3, or else we'll just finally get this resolved. So big picture, I see this as an opportunity to check your data flows. Don't panic. Nothing, you know, the world's not stopping, and see what you can do. So next slide, please. Okay, so what CrownPeak does is we have a robust partnership. So we work with AWS for hosting our services, and you can see that AWS has, you know, many certifications, and what we do at a base layer is we try to match our certifications to AWS. We put our software on top of theirs to maintain hosting consistency. And what this does is it has the effect of giving our prospects and partners confidence, and it indicates that we, you know, that we take data security very seriously. So as you can see, we're still going to maintain Privacy Shield, and as far as I know, I don't think AWS is not going to maintain it. Now, what that means by maintaining it is that it's administered by the U.S. Department of Commerce, but it is not seen as a legal basis. So as long as we're, you know, as long as there's some legal regime that we're valid under, we're just going to keep it, and you know, so we don't have to restart when it comes back into place. So I think for any partners on the phone, I think relying on AWS for hosting and trying to match your certifications to them is very helpful. It gives anyone you work with confidence that you're taking, you know, that you're adhering to best practices. Next slide, please. So one of our products, I'll go through this real quickly. We work with Ernst & Young and Epsilon. One of our products is DQM, Digital Quality Management, and that deals with the governance of your data. So we have a tool that assesses, you know, usability, accessibility, SEO to make sure that you're compliant with certain standards around the world. So the fact that we can adhere to these standards means that it's important that our customers do it. So, you know, companies such as E&Y and Epsilon, and this isn't a sales plug, it's just, you know, how we adhere to best standards because it's so important in the world. So it gives, you know, confidence that we are stewards of data governance and your customers. So next slide. So this is a big thing for us. This is what I spoke about. Sunir's question is how we handle data. We have AWS facilities around the world. Right now, most of the data is hosted in Norfolk, but our DQM solution, which I just described, that's based in the UK, and our hosting is actually, you can see those two red boxes. If I had the pointer, you could see the two red boxes, one in Ireland, one by France. That data is hosted in Ireland. So for DQM, we don't even have to worry about having a transfer mechanism. But for other data, let's say we have someone using it in Australia, and we do have Australian clients, like their data is hosted in Norfolk. So we have to assure them that that data that, you know, gets through the big cable undersea, that we're adhering to, you know, multiple standards. And I think having AWS, you know, to any company out there that's turning up an app or a cloud solution, using AWS gives you a major advantage in these discussions. It doesn't mean that you don't have to go through these processes and figure out what works, but it gives you a major leg up when you can, you know, when you can come and say that we have AWS and we've, you know, if you have a deal with AWS, they're going to go through and make sure that you're adhering to certain standards. Next slide, we're getting there. So all that we've talked about is moving data. So this slide shows you, this is based on CrownPeak Tracker Map. This shows you that all the data, you have no idea how much data you have on your site. So even though like CrownPeak has international data flows that we use through, you know, Privacy Shield and how we host our product, if you just go on to CNN.com, I mean, for example, look at Crux Digital. There's a direct connection from CNN, and there's, I tried to count before the call, there's probably like 5 other connections. So there's so much data out there. Like, how do you even know what's where? Like, we call it the Frankenstack, and that's what's become the issue today in the last 5 or 10 years is there's just so much freaking data out there. Like, how can you keep track of it? Like, yes, we have all these standards, but how can I assure, you know, customers, prospects, website visitors that we're not sharing it or leaking it to anyone? So but don't forget, as you know, as the data person, you're still responsible for this. Like your company, anywhere this data goes, and whether it's under Privacy Shield, GDPR, CCPA, or whatever regime is out there, you're responsible for knowing how and where this data moves. So what can you do with all this data? Like, it's so overwhelming. And that goes to the next slide. So what we recommend when we work with our partners, because, you know, we're really a data company, is we encourage you to be, you know, we don't like, you know, what's happened with GDPR is we call it the privacy theater and the cookie apocalypse of cookie consent banners. Like, they're all over the place. And for me, I was in London last year. I just clicked. I had no idea what I was agreeing to. And I'm a lawyer. I have, you know, 15 years experience, and I still have, no idea what I'm agreeing to in every site you go to. So what at CrownPeak, what we try to do is we're trying to build transparency into the approach. Like we want the customer to know how their data is being used. And part of these use cases that we described, develop comprehensive sites, consider rich media, build consent into the experience. Don't just have it as an obtrusive cookie. Like make it a part of the experience so that the customer knows that you're providing useful notices. They know they can trust you. You're not just there to pull a quick one on them and sell their company to some data mining company or ad tech company that's just going to use it for nefarious purposes. So our main theory for everything is data equals trust. Data is your moat that gives you your competitive advantage, but what comes with that advantage is trust. And that's really what matters to every customer. So, and then the next slide. So all of this is part of our PrivacyUX platform. And what we're trying to do is, PrivacyUX comes at the intersection of IT, marketing, and legal, which is security privacy. Like marketing, their chief concern is, demand gen. IT is concerned about secure infrastructure and uptime. Legal, my main concern is requirements and risk, but not all of these have to be mutually exclusive. We can work together. Like for me, for example, as the lawyer, my job shouldn't be just to check boxes. It's to enable the company to build better customer experiences. Like how can it work together? And what Privacy, UX does, it basically gives you an ability to understand your customer, and it gives you a greater ability to compete by building trust and developing high value experiences. So it's more than just data transfer. Like this is the last slide. There's one more slide if you have any questions. But the whole theory here is that Privacy UX is more than just about, what law is coming out, what do I have to do to comply? It's more of a plan, a long-term thing. So at CrownPeak, we study the laws and we're prepared, like what's gonna come a year or two out. And my CEO, my whole executive team places, key importance on how we manage data. It's the most important thing that we can do for our customers, and that's built into the DNA of our company. So with all that said, we're ready for Privacy Shield. It's not hard to integrate into your experience if you really think it through and act strategically about it. It shouldn't panic you and it shouldn't worry you, because reading through 200-page CJ EU decisions is not how you want to spend your time. You want to build your business and help people grow. So with that, I turn it back to you, Sunir, and thanks for your time.
All right, thank you. So I want to say the bottom line here is from the CrownPeak experience. You went in, and we put on the blog. So William was really, really kind, and he wrote out everything that they did in a nice bullet framework. But they went through it systematically, and they just tackled it like any project that would be familiar to an engineering company. Problems were created, solutions were made, and they just went from here to there and made it happen. And like the biggest issue, if I was going to summarize, you had two main parts of what you did. Is one, you just moved to standard contractual clauses instead of relying on the Privacy Shield, and EU hosting as well. Is that correct?
Yes, correct. I would say with the first point, we're still in our data processing addendums, our DPAs, we still leave Privacy Shield in there, because I feel if you just show standard contractual clauses, that's not sufficient enough to show that you've undergone a self-certification process. But yes, legally speaking, the basis is SCC, but I still think if your company has Privacy Shield, don't get rid of it. Don't let it lapse.
And it's still legally enforced, so you can't get rid of it. For certifying a Privacy Shield, it's still the law in the United States.
In an interesting way, it can only work against you at this point, because it's not a legal basis for transferring data, but the Department of Commerce, they haven't filed any claims. They can come and say, hey, CrownPeak, you're not compliant with Privacy Shield anymore. So
in the magical world when the Privacy Shield is enforced.
Exactly.
Well, that's the other thing. So let's talk about, I want to get into the partnership cases. There are 3 partnership cases: integrations, channel partnerships, and partner marketing. But let's just finish table setting. This is not just about GDPR in Europe. Abbie, actually, you could probably speak more clearly about this. There are multiple other countries that are aligned up with the OECD privacy framework. Like what else is going on around the world beyond GDPR that's kind of GDPR-like?
Well, I mean, there is the LGPD, which is the sort of like the Brazilian GDPR. I mean, there are a few differences, but it's clearly inspired by the GDPR. And I think that the GDPR really sort of pushed in, not just into like the public consciousness and people being more aware of what happens with their data, But also it sort of inspired a lot of the similar kind of laws in various countries. There's one that's sort of been in discussion coming out of India, also in the Middle East. It's sort of been happening all over the world. And then also in California last year, there was the CCPA, which isn't exactly GDPR, but it did like, let's say, grant additional rights to Californian users, which also made a lot more US companies actively involved in privacy. Whereas in the past, maybe some US companies felt that they mostly had US clients, so they weren't necessarily focusing on the GDPR, especially with smaller companies. So that also kind of pushed that into the forefront. So there's a lot happening and a lot more to come, like within the next year and more.
I mean, Argentina and Japan, the United States is being surrounded by countries with privacy regimes that are compliant with the OECD privacy framework. One thing about the CCPA, which is the Californian law, the EU, I can't remember who it was, the EU, some director called it GDPR ultralight, as basically saying it was meaningless. What is the difference between these? If I'm saying I'm CCPA compliant, aren't I compliant?
Yeah.
The answer is no. So what is the difference between the CCPA and the GDPR? Like that makes you look down on it?
Well, I wouldn't say look down. I mean, we actually did sort of have like this comparative chart that goes into more details. But like one major thing that stands out is the US approach tends to be more of a opt out. So it's like, you know, assume first, ask questions later kind of thing. So it's like, we're already processing your data, but if you don't like it, you can opt out. Whereas from the EU side, I mean, there are ways that you can still kind of take that approach, but generally you ask for consent first and you get informed consent. So it's like, we want to process your data for specifically these things. Do you consent for this particular purpose? Of course, there are, you know, some companies that are relying on things like legitimate interests, but that can sometimes be tricky because users have the right to object to that processing. So I mean, the main thing, like on the surface level, I would say is you're looking at kind of like an opt-out versus opt-in.
Yes. So that leads to like the core principles of data privacy in the GDPR and across the OECD countries outside the United States. But it's basically the individual is a data subject, has rights to control information about themselves. And I think one thing that is confusing, Micky, we talked about this, maybe you can explain it, but a company name is not protected by GDPR, it's individual. Can you explain the difference between company information, which is generic, and an individual?
Yeah, so individual information is information that is personally identifiable to a specific user. So whether that's email address, telephone number, even IP address, they've stated under the definitions. Obviously, company information to an extent doesn't fall under the remit of GDPR or under the scope if it's in the public domain. However, if it's private information restricted for company confidentiality reasons, I do believe that that does form part of data protection regulation.
Yes,
well.
There's one interesting exemption to the company name is that if it's a sole proprietorship or an individual could be implied from the company name, it is actually protected, which is complicating. Although I've never seen a case in the EU on that topic specifically.
No. I think, and also obviously, you know, if you're holding or collecting data or transferring data for non-commercial purposes, then obviously that's out of scope as well. If it's like, you know, for personal reasons, that it states that obviously in the regulation too. But your point about the individual participation of, which is the OECD principle, that marries up with the individual rights that the user has. The right of access, right to restriction, erasure, that kind of thing. You mentioned the point, I think we had the conversation we had about where there are kind of middlemen in between, or there are sort of third-party suppliers and vendors in the chain between the user and the end company. So I did a piece on this, I think it was about 3 years ago now, before GDPR actually came into force, where I actually mapped out sort of how the ecosystem from a user visiting a brand's website and then goes off, their data has gone into an ad exchange that's gone off and been traded across multiple exchanges. And then when they hit a publisher site, they're seen with an ad from that brand that they've just visited, like, you know, the day before or what have you. The way that I've seen that working in terms of under GDPR is a joint controllership agreement between the brand and the suppliers or the other technology providers within the chain that are doing something with that data. So if they're trading that data, if they have control over what happens with that personal information, they are automatically a joint controller under GDPR. So this then leads to reviewing contracts as far as, from what I've seen anyway, and again, preface everything, I am not a lawyer. I've just, you know, looked at the GDPR. I've gone through the.
None of us are lawyers. We're just making this up.
Yeah. Yeah, William aside.
Yeah.
Yeah.
So,
So,
blame you.
So the way that I've explained this to clients who I've worked with is that you need to look at your standard contractual clauses, or up until 16th of July, if it was a US company that you were working with for marketing or advertising purposes, then you need to obviously check if they are registered under Privacy Shield. Obviously, that is the matter. Well, people.
So we got called to the carpet by Jeff Matan, who made a very good point that he wants to get down to the brass tacks here from a partnership person. Let's do it. Let's answer. We're too academic. It's a good point, Jeff. So let's answer some questions specifically around partnerships. So there are three big cases that we need to deal with. One are integrations. Number two is working with service partners and channel partners. Number three is your own partner marketing. So let's start with the partner marketing because it's the easiest.
Actually, if I could jump in here just 1 second, I just wanted to point something out that's like, it's overlooked a lot, but it's important, which is like internal records, because people always think about the front facing side of the GDPR. But in quite a lot of cases, like maintaining records of your own processing activities are mandatory, and it also makes this process a lot easier as well, just understanding how you're handling your data, and of course keeping your records of everything, who interacts with the data on your behalf, or third parties, and that kind of thing, as well as your security measures and things like that. So as you mentioned, the 3 points, I just wanted to point that out, that's really critical as well.
Absolutely. There's actually, I put a checklist of things in the blog posts, things to look for, like audit logs, penetration tests, controller, like which officers of control. That's all in there, things you can check off, because this is too detailed for this podcast. But so partnership marketing, that's probably the easiest, although there is a difficult case. The biggest one, of course, is that if you're using email marketing or partnership relationship management, it's not that different from email marketing. It's still the opt-in consent, right?
Yeah, I mean, you're having to rely on email data that have physically opted in, and you've got a record of the opt-in of the consent as well, because obviously, should the data subject request a download of what you've done with their data and who else has got it, you've got to have that trail.
Yeah, and so that goes to the actual weird case in partnerships where your partner's customer data is in your marketing tool, because you're doing through channel marketing automation. Or they put you into the customer data into the PRM as prospect lists. Those subjects also need to show, there needs to be some consent basis there as well. Correct?
Yeah. So but the way that I've read it, and the way that I've portrayed it to clients, is that if you're working with third parties, then you have to make sure that within your contracts with your third party partners, is that you clarify where does responsibility begin and end with you and with the partner and whoever else they're working with along the chain. So you've got to have that trail in your contracts pretty much before you agree to work with that vendor.
Yeah.
So that's something that you're going to have to, as an individual, decide with your partners.
And I would add to what Micky and Abbie said, like Jeff had a great question, like to bring it down and not keep it academic, like know who your partners are, know who your vendors are, and know where that data is going. And if you're not big enough to have a legal team, or if you are, like that should be in every deal, like know what they're doing with their data. Like we will not sign a vendor or a partner until we know how and where their data is used, and that there's, certain protection and requirements. It doesn't have to be a big project. It's more about what we do at CrownPeak is a strategy management, like how you handle transfers of data and just knowing what's there. It's not the fun part of it, but it's necessary. And I think in the long run, it builds better relationships.
Yeah, so if you're gonna like make an algorithm for you to analyze, like look at a partner and go, okay, this is the stuff, the checklist, you know, one is, do they have consent from the data, like the customer, to pass their contact information in? They can't just give you a customer list, and conversely, you can't just give them a customer list. That can't be done
No, and
without,
we don't want that.
no, that would be bad. Although like, there are some companies who are doing that. That are not compliant, and it's concerning what's going to happen to your, if you taint your database with customer lists from outside, you don't know where it's coming from, then you have to burn out your whole customer list potentially. So be careful where this data is coming from. Always have a data source and a date of consent logged against the contact information, or you're going to lose that contact record. You're going to be deleted from your, you'll be forced to remove it eventually. When you are, if you're going to share contact information with a third party, you have to name that third party explicitly to the customer, and they have to explicitly agree to it. Is that right?
Yeah, and include the contact details as well.
Yeah. An interesting case is you can't, it came up, you cannot actually, this was actually prosecuted. You can't link to a partner directory. It's not specific enough. And you can't have a long, and you can't conversely then take every partner in your partner directory and put them in the contract by name. It can't be an onerously long list. You can't put like hundreds of potential people you might be sharing this to. Like suppose you want to send it all to your agency partners. But what you can do is have the customer explicitly opt in to your partner program, like, you know, like an Upwork or LinkedIn. You just sign into that social network, and anyone in that network can talk to you. That's fine, because the customer knows you're in a network and they're going to be communicated to you by any partner. So that's the partner marketing side. The account mapping is probably the most complicated one, because there are two parties that need to consent. Both the customer and the sales reps on the other side both need to consent for contact sharing. So especially under CCPA. So explain this. I mean, this I didn't really understand. So under CCPA, how does this work? So like the sales reps have to agree somehow to be part of the account mapping. Data sharing, how does that, what does that mean?
Can you repeat the question again? Sorry.
Yeah, under the California Protection Act, does anyone know how this works? Like the sales reps have to opt in, right? Before their own contact information is shared with the other partner. Like Wayne Sisk is actually saying this. The data sharing is also an in-depth issue in the CCPA as like a constitutive sale. Interesting point as well. Maybe Wayne, you know.
Yeah, that's a great point actually. So data, CCPA is, they're coming up with something called CPRA, which is on the ballot November 3rd. It's expected to pass by 90%. So CCPA doesn't fully address sharing right now, and that's a big thing with ad tech. Right now, CCPA calls for the quote unquote sale of information. So with that, with my slide where I showed you all that data leakage that's on your site that you don't know is being shared, the big debate under California is whether that constitutes a sale or sharing. So for now, it's questionable, but when CPRA passes, that will all be considered sharing. And then, you know, you really have to get your house in order.
Right. So on the account mapping side, you have to be careful. You can send the company name, like the trade, like industry and high level public data about your customer list, but you can't send individual contact information. And you just basically able to, I mean, the basic principle is always opt in. Ask people before you can make an introduction, before you do the introduction. It's not that
Yeah, my theory is always default to opt in. Despite California differing from GDPR, I think it's always best to opt in. It's just that it's the default. People feel comfortable. They won't come back to you 6 months later saying, hey, why is my data here? Why am I getting these emails or these marketing calls? I didn't sign up for this. So if you're very clear and honest, that's how you build I mean, it all goes back to trust. It shouldn't be seen as a checkbox. It's really a way to build trust and let customers know why you're using their data, how you're using their data, and if it's going to help them. Most customers I find will opt in if they know it's going to help them. Like it's not a bad thing to be served ads if they're going to help you, and if you build the relationship and progressive consent and trust based on that, there's no reason why customers won't opt in.
Yeah, fantastic. So
let's
go ahead.
Oh, I was just going to say, just to add also in agreement, also you're kind of, let's say if you're on the marketing side, more qualified leads, you know that the people that you're reaching with this information, whether it's targeted ads or whatever, that they actually understand and want to receive it. And just to touch on something William said about the consent, even with this CCPA, but also if you're also touching on the GDPR, if it applies to you, it's really important to make sure that you're keeping the records of your consent as well, because sometimes that might happen when someone might challenge you contacting them. For example, you need to be able to prove that you did actually, you know, collect valid consent. So that's always something to keep in mind, keeping proofs of your consent, records of your consent and things like that. Even within the situation of partnerships, which, I mean, we do like a consent solution that kind of automatically tracks this, but more or less you want to make sure that you're kind of keeping note of how they consented. Timestamp is useful as well, like, and if it was online or any agreements were in place when the consent was collected. These are all things that kind of go hand in hand in maintaining these proofs of actually having consent if you're processing data based on that.
Absolutely, and it's a legal requirement, I would add to that. So it's not only a best practice, it's a, you know, it can only help you.
Yeah.
Okay, so talking about data sharing leads us to the integration case. So I think this is really important to understand the difference between a controller and a processor, which are very high level terms, but there's a simple way of understanding it. Micky, like, maybe you can answer this, like, very simply, like, a controller is this and a processor is this. What is that? What is it?
A controller decides what happens with that data that they're collecting. The processor is acting under the instruction of the controller what to do,
right?
And cannot deviate away from what the controller says.
So this actually makes integration cases pretty much more straightforward. So there are a bunch of different cases, but the primary one is when your customer buys software from you and then buys software from someone else and then wants the two systems to connect. So in that case, what are your responsibilities?
I would say you'd need to, depending on the company and what software they're integrating, where that software is hosted. So, you know, there's several things that come into play. You've got to review the software that you're planning on integrating and making sure that they're compliant.
I mean, you're not the one making the decision, right? The customer has made the order to move the data. In that case.
Sorry.
So if I have MailChimp and I have Eventbrite, I want to move my Eventbrite data into MailChimp. I made the decision to do that. Eventbrite didn't make the decision. They're doing it because I told them to do it. In that case, I'm the controller, they're the processor.
You've instructed them to do that. So you've made that decision, not the third party.
Not Eventbrite. So Eventbrite is not responsible for confirming that's okay.
Yeah, I would say it would be you because you're the person that's made the decision.
And what about and then the case, and then there's the converse case where you're basically embedding, or you've contracted with a party where like a cloud connector to do the integration work for you, or you've extended your product with another product, like, you know, Stripe Elements is a good example. People put that on in their app. Then you've made the decision. So you're responsible. Is that correct?
So you've done that under the agreement of a performance of a contract, have you?
Yeah, so it's a sub-processor, but basically you have to make sure they're compliant in that case.
Yeah, I mean, and if you're using a sub-processor, then obviously, yeah, it's down to due diligence to make sure that the relevant technical and organizational measures are in place with the sub-processors.
And William, you basically alluded to this in your presentation. You had to go through your stack and verify it, but like what did you have to do to work with tech partners and verify they're compliant?
Well, what I did when I first came to CrownPeak, it's been around since 2001. So the first thing I did 2 years ago, when I came over, is I talked to the exec team and figure out all our vendor contracts, how they work, what information is flowing where. First get your hands around it and figure out what's going on. See if there's agreements in place for how the data is handled. If not, make sure they're put in place. And this also happens to us on the vendor side, like if we're vendors with customers, or we get constantly when rules and regulations come up, like new paperwork to sign and make sure that we're compliant with. So, and we have a data processing addendum, and within that data processing addendum, all those factors that Micky addressed are in there, like technical and organizational safeguards, what we actually do. And part of that DPA, there's 2 ways that we can show that we're compliant. That would be, 1 is Privacy Shield, and 2 would be standard contractual clauses. So those are pieces of the puzzle. But the big thing is, I think you need to have a data processing addendum. And yeah, I guess, to the earlier question posted, do you need to talk to a lawyer? Probably. But if it's clear and you don't have that many vendors and you know where your data is used, you can probably figure it out yourself. But You don't necessarily have to speak to a lawyer, but I would speak to a company or someone that knows what they're doing.
It's not even that much you need to look for it. DPAs sound complicated, but they're just asking stuff like, where is the data stored? Who has access to it? Are they doing security reviews? Are they going to notify you in breach? I put a bunch of these questions in that blog post. But
Yeah.
you can self-check. It's not really that much. These are like complicated words because they're contracts, but it's a very simple set of principles.
Yeah.
Even you could just ask them in a call in like 10 minutes.
Right. And I think sometimes companies will follow and really beat you up on it. So I think it's always good to have FISMA, NIST, SOC 2 obviously is a huge one, because that shows that you've gone through, a full exam and full background and accounting of your company. So it gives, people will do business with you if they know you handle their data well.
Yeah, especially at the enterprise level.
Exactly.
All right, so moving on, let's get to the more complicated case, which is the channel partners. So this is when you're working with a service partner, someone who's not a software company, who's managing accounts on your behalf. And if I was going to Soapbox, which I will, having looked at, so this is what my company AppBind, we're working on solving this problem. I've looked at a lot of agreements here, and I think people get really confused with cloud software because they're using contracts from the licensed software environment or arrangements of licensed software where a company would go and buy and install software for the customer as a value-added reseller. That works because you're putting a copy of the software on a computer that's in the customer's offices, and you can just walk away. The data is never out of the customer's control. But with cloud software, the data is never in your control as an implementation partner. You never have control of the computers. Like, you have no ability to deal with this data risk because it's a software company who's actually managing with the data center, and that liability never disappears because the customer never controls their own data directly. They're always using the software partner. So if you're ever, the contracts where you're setting up your channel partner to take on liability are nutso because they can't do anything about it. It's actually part of the software as a service, the service part of the software as a service that you are promising to the customer, and therefore your channel partners, you're taking on the data risk. So, but I mean, Micky, you worked at ad agencies, so I'm going to put it to you. If you were a marketing agency, what are your responsibilities if you're signing up for, say, HubSpot and managing for a customer? What do you need to agree to? What's the basic bottom line for your channel partners?
So, well, bearing in mind that I've been out of the space for about 3 years now, but when I was in the space, we used, this is back in 2010 now, at a very large ISP stroke ad network, and they implemented a very well-known CRM system across the entire company at that time. So a cloud-based CRM system at that. So if you read the T's and C's of that cloud services provider at that time, they basically said that whatever information you're inputting into that CRM, they can use that data for marketing purposes on their own right as well. That under GDPR, I mean, basically it falls foul. It's a major infringement of doing that because you haven't been given permission by the customers whose records you're putting into that CRM, that the cloud service provider can do what they like with that data from a marketing perspective. In actual fact, you've probably seen in the last couple of weeks the latest, I can't remember if it was Schrems or if it was somebody else now, the complaint against, I might as well say it, Salesforce and Bluekai, where well, if you read through the complaint, you'll see that the full details in there. But ultimately,
if you're an agency, don't touch the data. Like, what are your responsibilities? Like, you need to agree because you're managing. It's like, who do you work for?
Well, this is the thing, because when you sign an agreement with a cloud services provider, you're signing up to their T's and C's.
Yes.
So if that cloud service provider was breached, if something happened in one of their cloud data centers and all that information leaked out over the open web, the ad agencies are going to be like, well, hang on a minute, you told us that we're responsible for this, but it's your breach. Yes. So you're going to start getting into a whole litigation to and fro, and in the meantime, millions of customer records have gone out into the open web through a fault of.
And William, you in your channel program, you are pushing the liability into your channel partners, but you solve this by contract.
Yeah, so our policy is if the channel partners, if they're servicing our product, then we treat them as independent contractors. So we're separate parties, but they are held to an NDA, a non-disclosure agreement, or confidentiality provisions like they're one of my employees. So we hold them to that. And if they breach that, the liability is on them. But if the product itself breaches, then, you know, that's obviously on us. So we're very clear, like, where the responsibilities lie. Like, you have to lay that out at the outset of the relationship.
Like, the analogy is a general contractor who installs a furnace.
Exactly.
Yeah, they
with
screwed
the
up
furnace.
and exploded. It's their fault. But the furnace is manufacturer default. It's a manufacturer. Yeah.
Right.
And then,
whereas the breach is the same as the defect, right? In this case, the breach is analogous to the defect.
and like my opinion, honestly, is because these ad agency service partners have no control over what you're doing with the product, the customer should just have direct contracts with you as a vendor. Yeah, they're basically acting as aspects of the customer, not as aspects of you, right? In most cases, in some cases not so. Like if they're a reseller, but most cases these implementation partners are contracted with the customer, and they're really aspects of the customer. And all they need to do is have a confidentiality agreement, et cetera, with respect to the customer, that they're not going to take the data of the accounts and do something crazy with it. But you have a case though where you have resellers on the other side that are contracted with you to do the support, but you're saying you're indemnifying them from the product defects, basically. If you breach, you protect them.
We would. So with a reseller, we would flow down the confidentiality obligations and the restrictions on the license use. We would flow that down to the end user. But then the reseller would push the liability back up to us as far as product defect or breaches that are caused by us if we're hosting, which you know, under a reseller, hard to see a scenario where we wouldn't, but you know, anything happens in this world. Yeah.
So, I mean, the basic idea is who owns the customer, who's the customer dealing with, who's representing they own the software to the customer. Interesting case is white label. So you can't actually white label completely under GDPR. Because you need to disclose any of the companies by name explicitly. Abbie, you're nodding your head, but this is right? So if I wanted to hide a software vendor, I can't do it because I'm sending the data to them. I have to tell the customer at some point they have the data. Is that right?
Yeah, the customer has the user has the right to be informed about what's actually happening to their data. So you do have to disclose it. So even like with our policies that we generate, we have white label options available, but it's mandatory we disclose that we do process data on behalf of the customers. So
yeah, I mean, that's an interesting, I think a lot of programs, the white label programs, are not actually compliant in this vein. Everyone needs to know exactly where their data is going explicitly, and that's the regime we're moving towards. No, it's just the way it is. Things changed. There's one more case I want to talk about, if like that is really complicated, are these master sub-account situations, where a lot of people have these, where the agency buys the master account and they set up customers underneath them. Like that is a really complicated case because data is being mixed together and the owner of the account is not the customer, it's the agency. So who's a controller, who's a processor? People are controllers and processors. What's the story? Micky, you chime in, you laugh.
So I guess it depends on the context of that, but if you're purchasing a platform and then you're going to set up like parent-child accounts within that platform, then the onus really sort of lies on the person who's purchasing the platform and what they're going to do with it after that. The technology is being sold to the agency. How the agency sets that up is obviously under the control of the agency owner, I would say. It would have to, obviously it depends on what data is being collected as well, and what information is being segmented between who has the master view, who has segmented view, and does what with that.
Yeah, so I wrote this out quite extensively because it's the most confused I see out there. But it really comes down to a simple test. I think, in my view, is like it's basically the carpenter's test. What's the output of this product? Like what are you giving the customer? Is it just a PDF or a spreadsheet? Then they never have to log into the account, like, you know, an SEO keyword report. Then it's really your carpenter's tools, your workbench. The customer, you're the agency's the customer. They're just having a folder per customer because it's their workbench per customer project. That's one thing. There's no customer data in there. The customer never needs to have access to it. But the question is, does the customer ever get to gain control of this, or is their customer data ever really in here that they need to force seize control for compliance, then you're going to need to do account transfers into the customer's hands. They have the right, and their data subjects have the right to have access to those accounts as a result, and that can get messy. And there's also one more issue, which will come up more, is horizontal liability. Now, I believe there have been cases in the EU about this, where what happens is that one account is legal, like there's a legal proceeding against one customer, and they get the data from the agency, and they get to see all the other customer data as a result, which means that you have to notify all those other customers that their law enforcement has just seen their account data for no reason. Is that true?
I think redaction would have to be in place if that was the case.
Yeah, that sounds sketchy to me.
Yeah, so to give you an example of this, I had an incident. Well, not an incident, but it was actually a client experience that the ICO had knocked on their door from a complaint from an disgruntled employee. And he wanted transcripts of emails, WhatsApp messages, SMS messages, written notes, anything that had been discussed about him by that employer. So I went in there basically and said, right, okay, well, look, have you got emails and have you got paper trails of conversations about this particular employee? And yes, we have, but it's got other people involved in the conversation. I said, right, okay, well, you need to hold off on that right now, because you could be you could be holding other people, that innocent parties, basically disclosing that they've been involved in these conversations, and you have to respect their privacy rights too. So you have to heavily redact a lot of the information that you've got, so that you don't the term that escapes me now, but so you don't basically bring in these other parties as part of the case. Otherwise, you'll be fighting a bit of a wildfire, really. So yeah, I think from your example there, Sunir, and as long as you've got heavily redacted correspondence, then the participant or the data subject, can only actually see information that's relevant to him or her, and not anybody else.
That's only for the data subject. Law enforcement, if they trip upon something in the course of their investigation, then it's exposed. So that is weird. So it's better to separate. I mean, isn't it? It's better to separate customer data into separate accounts that are separately managed in your system. Don't mix data. Was the bottom line from that story.
Oh, absolutely. I mean, you don't want to mix data anyway, because you need to have it in some kind of filing system, really.
Yep. There's one more question from
structured in a structured system. Sorry.
There's one more question from Wayne, I believe, looking for other template DPAs available, but I believe these are the ones we have on the blog post in the ICO. Is that really right? Really, these are the standard contractual clauses.
And I made a comment to Wayne, just be careful about, they're great templates, but be sure to read them and know what you're agreeing to.
Yeah, the ICO ones are good because they actually have like commentary on every single clause that you can you can make a So they're in that blog post, Wayne. Okay, I mean, this is.
And I just wanted to add, we also have like a few sort of just free templates on our like documentation section, because of all the work we were doing with the GDPR. Some of the agreements that we used for ourselves, we just made them available for other people as starter templates. It's always better to have a lawyer involved, of course, unless you're really sure you know what you're doing. But we also have like some free templates for like data processing agreements and e-representatives and so on.
Actually, good point. So Abbie, maybe you can send some links. I'll add them to the resource.
Sure.
It's a living doc. Okay, thank you, everybody. This is a very complicated and mind-numbing conversation. It's about doing the right thing, I guess. It's also about us fighting the spy agencies for some reason. I don't know why we're doing that, but
I think you're right. I think if we focus on the customer first and foremost, then it's about doing the right thing, and it only helps us. It's not just a checkbox. It's arcane legalese, but really focus on, what we can do to help the customer and our clients and vendors do the best they can.
Yeah, and honestly, if you don't do it, and you customers get angry, so like if you don't opt in, lose your data, these are all bad things. You don't want to do any of that stuff.
If you can demonstrate trust and responsibility with the data, then that's going to lead to better relationships all through.
Exactly.
And on the other plus side, like even just keeping the principle of data minimalization in mind, it also helps you to kind of streamline your own processes, make sure that you're not like exposing yourself to all these extra liability by processing or bleeding and data that you don't even really need for the purposes that you're using it for. So it can be a good thing somehow, the data laws and finding ways to work within them.
Well, I salute anyone who's made it to the end of this 1 hour long
Yeah, well done,
video
everybody.
now and in the future. We have we're just fire questions away in the blog post. We'll keep improving this thing. We need a common resource for these. And I thank again Abbie, Micky, and William for helping me improve this guide. We'll get there as an industry. I appreciate it. I'm gonna go have a drink now.
Thanks for inviting me.
All right. Thank you guys.
Cheers.
Thanks guys.
Bye.
Bye.
Bye.